Good afternoon to all. This special lecture series program is organized for undergraduate students on finance and its allied areas, organized by Kolkata Bidhannagar Society for Academic Advancement, West Bengal, India, coordinated by Azure Academic Services, West Bengal, India. Today's topic of discussion is IPR and IT Act 2000. Today we have our special guest, Dr. Koyel Roy ma'am. She is an assistant professor at Arka Jain University, Jharkhand, with a PhD in law from University of Bardhaman. She holds an LLM in corporate and commercial law from Christ University and a BA LLB from the University of Calcutta. Dr. Roy is an accomplished academician, author, legal researcher with multiple patents and publications in prominent journals. She is actively involved in legal aid and student wellness initiatives. Welcome, ma'am.
Thank you so much, sir, for the warm regards and the warm wishes that you have given me and the introduction. Thank you so much. So, shall I start?
Yes, ma'am, please start.
Yeah, okay. So, good afternoon, everyone. So, today the topic is very interesting because the topic itself talks about the intellectual property rights and the IT Act, that is Information Technology Act 2000. Because in this juncture where AI, artificial intelligence, where we are having so many conference and seminars relating to artificial intelligence, we need to understand the crimes that are happening through the intellectual property rights. And in say physical, we have a property where we say this house belongs to me, that car belongs to me, that mobile phone belongs to me. So it is visible, right? But intellectual property is also a property, but it is intangible, which is not visible, but yes, it's felt. We can, like, for example, today I have a book. I have written the book. I'm an author of the book. So I am having the property. So that particular book belongs to me, and the entire authorship belongs to me. So in that case, that is also property. But yes, again, as well, many of the people don't know that there is also property known as the intellectual property rights. And yes, when we are talking about rights, intellectual property is just a property. If you don't claim, it will just become a property. If you claim it, it is your rights. So we need to know about our rights. There are copyrights, there are trademarks, there are patents, there are trade secrets, there are confidential information, there are geographical, the rights, because all the things are something which is not visible again, but it's felt. So once and again, just to start with the topic, we need to understand intellectual property becomes only a property until and unless you claim it. For example, today I have a book. It doesn't mean that I have a copyright registration. You need to go to the copyright office, which is available again online, and you need to give all the details and you need to file for copyright. Because any time anyone can come and say that that book belongs to me, or anyone can copy it, because everything is available online back to open access. So we need to know about the rights. So just to start, I have prepared a small PPT for everyone so that everyone can understand their rights again. So again, as I said, that intellectual property is also a property, just like a property or a house or a car or a mobile phone or a watch, which we are wearing, and we are saying that's my property. Similarly, intellectual property is also property which we should claim. So just to start and begin, I've started with an overview where you can see that intellectual property has patent, trademark, and copyright, and its infringement and certain case studies, which we'll look into the later part. But the main intellectual property which is governed in India is patent, because most of the intellectual property is protected by the Patents Act. Even the design, for example, today there is a bottle or Coca-Cola bottle or any Pepsi bottle, see into consideration, that particular design is protected by the Patents Act. Even geographical indication, or their Patents Act also, all the things are governed by this Patents Act. Copyright is something different because that is governing the literary works, musical works, photography, cinematograph. All these things are governed by the Copyright Act. And trademark is, for example, I'm doing a business, any kind of a business, that particular mark which is giving me the goodwill of that particular business is coming under the trademark. So WIPO goes without saying. The World Intellectual Property Organization is basically a specialized agency under the United Nations, and that is protecting the intellectual property throughout the world. I mean, WIPO is the main, you can say the main mother of all these laws, because anything which happens, the WIPO is the main specialized agency under the United Nations, which is promoting and protecting the intellectual property, and its headquarters is in Geneva, that is in Switzerland. So you can say that the laws that came in India and the other countries are actually, they are having a treaty with the WIPO. Like India is having a treaty with the WIPO, UK is having a treaty with the US is having a treaty with the WIPO. So World Intellectual Property Organization is the kind of an agency which is protecting the entire intellectual property rights, which is governed entire in the entire world. So along with that, we have we celebrate April 26th of each year as an intellectual property rights day. So why? Because World Intellectual Property Rights, this particular visionary and innovation was created in this particular day, 26th of April. That's why every year, 26th of April, we celebrate World Intellectual Property Rights Day. Everywhere we can see a lot of conference or seminars that took place, and even certain FDPs like faculty development programs also try to happen because of this particular, keeping this in mind that intellectual property rights is a very very important rights which most of the people, don't know. I mean, I should say that the police personnel also are not aware of this particular fact that yes, there are infringement. They are only focusing on the property that people lives in, civil properties, property matters. But yes, intellectual property is also a property. Infringement do happen here. We should focus on this because we are shifting our world from a physical world to a digital world altogether. And after coronavirus, after COVID-19, we have seen this platforms like YouTube or Google Meet or Zoom or Microsoft Teams. All these things are very much favorable. And nowadays we tend to have conferences virtual or hybrid mode so that people should come to know about it. It's not possible for everyone to travel physically to there. So in a way, it is a good thing. But yes, again, the dispute and the protection comes to the first and foremost importance. So that's why on 26th of April, we celebrate WIPO's birthday, and we try to, make people aware that yes, this is intellectual property, and we should protect this like that. This is the main visionary that should be there. Because see, day by day, people are inventing something. Today, with the colors, I'm inventing something, artistic work. Today, maybe like Arijit Singh is composing a song. So Arijit Singh's song should be protected by T series. Okay. Today I'm making a content in the YouTube and making it public, and someone is copying it. So there should be some kind of stringent laws in the online so that if people are copying, that should come. Like this is totally copied. Then only I think that should be protected. That app or that application should be available in the digital era or the digital space. Now, coming to the intellectual property law in India. So, intellectual property firms are there. India, US, UK, Chicago. They are mainly focusing on the qualitative inventions. And we have certain kind of platforms also, like we have the ipindia.org, like gov.in, where we can upload our invention to the patent office, which is situated in Kolkata, Chennai, Hyderabad. So there we can, upload whatever the inventions that we have done through patent office, and they will go through that particular thing thoroughly, and then they will give us that yes, this particular invention is patent protected. Same thing goes for copyright. For example, I have created or I have written a paper in a conference. So the conference proceeding will give me a ISBN number. And thereafter, once I go for an edited book, there also the publisher will give me a kind of ISBN number to protect my work. And after that, I can claim for more protection through the copyright office. So there is copyright office. If you just type, you will get a login. You need to log in yourself to register yourself, and you need to give what is your work, whether it's artistic work, whether it's a photography work, whether it's a dramatic work, whether it's a musical work, whether it's like literary work. All these categories are there. You need to upload your work there. 3 months, 4 months time will be taken by the government of India. They will check it, and afterwards you will get a certificate that will make your case more stronger. If anyone wants to infringe your work, you can showcase the certificate. Just like property registration takes place, we becomes owner, otherwise we are just a possessor. Similarly, if we just publish a book, we are just a possessor, we are not the owner. To become an owner, we need to register ourselves in the copyright office. So now, what is intellectual property? As I said, to make the property your right, you need to register yourself. Registration is compulsory. See, in copyright, it is not compulsory. That's why copyright infringement cases are very much, you can say, not that stringent, not that strong. Anyone and anyone can copy your work because everything is available online. For example, today I type intellectual property rights and IT Act, I'll get a lot of you know things available in the website. I can easily copy paste. The author is not aware also that my thing is being copied. So copyright work is less stringent than the patent. Patent, when you are actually making your work patentable, you need to give signature, you need to give your name, your authentic, designation, everything, and your signature. So the immediately when you give your signature in the patent office, your name, your signature, your details, everything is there. So if anyone wants to copy also, na, it will be shown that it is in that this particular person name. I cannot copy that particular patent invention. I cannot say that it belongs to me. But on the other hand, copyright registration is not mandatory. Once you copy paste something, nowadays chat gpt is there, someone just writing it, everything is given by the chat gpt, and we are copying it. But again, there is no law for it. We cannot say it belongs to the robot, it belongs to the AI, because there is no law to say that the authorship belongs to the artificial intelligence. But yes, again, the ethics come here. Ethical consideration is also a very important thing in the intellectual property rights. If we copy someone's, the first and foremost thing that should come to my mind, whether I'm doing an ethical thing. Is it ethically correct? Is it morally correct? So as we can see in the screen, it says that it comprises of two things. One is literary artistic work, another one is the industrial property. So literary and artistic work belongs to the copyright, and industrial property belongs to the patent and the trademark. So how are they protected? For example, I said that I have published a book, paintings, music, or I have made a lyrics, or in a radio, TV, I have given certain lectures. Even for example, today the lecture that I've given, even that is copyrightable. No one can copy it without my consent. But again and again, how are they protected? Are they protected by copyright? Are we getting the protection? Is Copyright Act 1957 is actually giving me the protection? So let us see that what is Copyright Act giving us. But before that, as I said that as per the literary works and artistic works, it is protected by copyright, and the industrial property, that is patent, trademark, industrial design, trade secrets, geographical indication, layout design, all these things, mainly the names are different, but the protection is given under the Patent Act 1970. For example, today we have Roshogolla, which belongs to Kolkata, right? And we have like this sari, which is of Dhaka, to Dhakai Jamdani. So all these things are like the word Dhaka or Kolkata or Shogolla, whatever the things that I'm saying, the area is specified. So the geographical indication, but again, the protection is given by the Patents Act 1970. Even for example, I'm like designing something like any kind of designer, say into consideration Sabyasachi sari. Even Sabyasachi is like designing a sari. That sari mostly is coming under the design, the pattern, everything. But it is coming, the protection is given by the Patents Act 1970 because it is coming under the industrial property, something which is applicable to the industry, something which is new, something which is novel, something which is non-obvious, something which is applied to the industry. For example, people are buying it, people are wearing it, people are showcasing it. But copyright is not something which is coming under the industrial property. It is artistic, literary work, it is musical work, it's something creativity. Copyright is totally based on the creativity a person has. So moving to the types of intellectual property, which is again very, very important. Functional and technical inventions comes under the Patents Act 1970, which got amended in 1999 and 2005. So in the year 1999, 2005, there are huge amendments that took place relating to medicines, pharmaceuticals. So when we talk about medicines, like prior to that, medicines and everything were not coming under the intellectual property rights. But yes, after 2005 there was a huge amendment that took place in the Patents Act 1970, which helps us to understand the product patent and process patent. Instance, for example, medicine which is produced in US, the process is also patented, the product is also patented. So process and product patent both are patentable, and that is good for the people so that they cannot infringe it. Prior to that, only the product patent was patentable. So the, for example, if I can make the process in a different same manner and making a product in a different manner, that was patented. But to make the patent stringent and more stricter so that the owner gets the like you know more rights, that is why the product and process, both the patent got patented, both the process got patented. So this is all about the Patents Act. Now coming to the Copyright Act 1957, it is purely of artistic work or something creative. For example, today I'm making a earring or a jewelry. Okay, everything is creative. I'm painting something or I'm making something which is innovative. Okay, even a movie. I'm going for a movie also. Even those, all the things which is coming under its creative mind, that is coming as copyright. So Copyright Act also got amended in 1982. Amended means it got a lot of changes came in the act. So 1982, 1984, 1992, 1994, and last is 1999. So all these amendments took a major changes in the Copyright Act, and we still require a huge amendment in this because nowadays AI is taking a lot of picture in it. Artificial intelligence is actually making a lot of things easier for us, but again, this is making a lot of things to degrade. Like today, I command the chat GPT to do something, the chat GPT will make for me all the things. But then what will be the creativity of the person which is coming from the intellect of the person? So whether the intellect of the AI will be same, I mean the human who is using the AI intellect and making in its own name, will that be copyrightable in the name of the human? Or the Copyright Act should change as per the AI? I mean, the robot also should get, because as per the Copyright Act, there is nowhere written that AI can also get the copyright. So I think like the Copyright Act should get more amendments in the near future. So now we get the symbol, logo, word, sound, color, design. As I said, all these things will come under the Trademark Act 1999. And as you can see that the Trademark Act got amended in the year 1994, 1996, and 2000. Trademark is all about the logos or the kind of marks, all the kind of words, like it can be a slogan as well. Okay, so there are so many advertisement we can see because of the slogan. People remember that, like washing powder Nirma. So like these kind of slogans are very much famous, and I think people do remember. So even if the name of the product people forgets, but the kind of slogan is recognizable for everyone. So these kind of things are nothing but the goodwill of the particular business, and business means trade, and that particular business gets its recognition by the trademark. And you can see trademark has a small r, which is round shape, small r, and that is registered trademark. And if the trademark is not registered, there won't be any r, circled beside that particular mark. So if there is no R which is circled beside that mark, just make sure that that particular trademark is not registered. So these are the kind of intellectual property major types actually. There are a lot of types, even cultural heritage, people are going for intellectual property. Then we have this traditional knowledge like neem, then tulsi, all these things we know that if we eat it during, if we get cough and cold, these are something which are times immemorial, these things came up. But we don't have a protection for that. So this is also the, that's why these are the major types of intellectual property in India that we consider. So this is a kind of thing that I've just given to you so that you can understand. If you don't see a problem with this question, you need the class. So all I asked was, can I patent my copyrighted trademark? So that is a very hodgepodge thing, right? So patent is something, as I said, that it comes with the industrial design. Copyright means, again, which comes with artistic or creative mind. Trademark is something where the mark of the business is protected. So can everything be protected? Yes, it can be. For example, say for example, a mobile phone. You take a mobile phone, you will see, for example, I have a mobile phone of Apple. So the Apple mark with a half eaten apple is the mark of the apple, right? Okay. Now the software part is definitely it's patented. Okay. And on the other hand, the the color variations, once it gets open, how it will come, what are the creativity will come under the copyright. The design of the mobile phone will come under the Designs Act. So yes, I can patent my copyrighted trademark, because in a product everything is available. Just take a mobile phone and look at your mobile phone. Every mobile phone has a different shape. That is design. Every mobile phone has its different key features. Like there are so many wallpapers, so many cracks and so many WhatsApp and all these things are different for different mobile phones. That is the copyright. The software part is the patent and the mark. Like I have Apple, so I've given the like example of Apple. Someone is having Samsung, someone is having Motorola, someone is having some other phones. I don't yes, Oppo. So you can see the different kind of written part and the shape of the design. So that will come under the trade design and logos. So yes, this is the thing, we can do it. So now coming to each and every intellectual property rights, which I will make you understand by like discussing which each and everything. And the last part will be the IT Act, that is information technology, and how IT Act is encroaching in the intellectual property rights. That will be the last part. So coming to what is patent. So it is covered by the 1970 Act. We have a law in India which is protecting it. So, and it got amended in 2005. As I said, that the medicines that we are having, there are generic medicines which we get in 70% off in the government hospitals. That is because of compulsory licensing. But if there are like medicines which are like patented, it gets patent for 20 years, the process and the product patent. So if, for example, if I go for patent of an invention, so yes, before coming to patents, let me tell you this, there are three kinds of patents in India that gets protected. One is utility patent, another one is design patent, and third one is plant patent. So what is utility patent? Utility patent is something invention. For example, I have invented um, a kind of system like today if I upload this, the system will say that this particular software is copied from something. So I have made an app for this. I've invented that app. So I want to take the patent for that particular invention. So for that, what I need to do, I need to give all the very specification. So there are two kinds of specification. One is pre-specification, pre-grant specification. One is post-grant specification. What is pre-grant? Pre-grant specification is I have taken all the details of the invention, okay, and I have uploaded everything in the site of the ipindia.gov.in. Okay, so the government will see to it, government will examine it, and after that it will be published. Published where? Published in the website of the ipindia.gov.in. After that, the government will ask for objection, that anyone has any objection, because this is published in the public portal, so everyone can see it. Sometimes what happened, patentees stop there. They don't go for grant. They stop there and they show that their patent is published. But if you want to go for grant of patent, the further will be examination. That is post grant. Pre grant is done. It's published. Now it will the next step. The next step is they will go for, after the objection, no objection comes, they will go for the examination. So the in the patent office, there either you can file it by an agent, or if you are filing it, you have to go, and there will be a kind of examination where you need to you need to present your invention. What will be, whether it's new, whether it's non-obvious, or whether it's applicable in the industrial design. In the physical world, what is its need? Like today, for example, I am inventing a bomb or nuclear bomb, right? I cannot do it because I know if I invent that bomb, that can destroy my country, and I have no right to do so. So in that case, it will be totally rejected. So under patent, what we can do, Patents Act 1970 have a list of inventory thing and non-invention also. So today, if I'm inventing a kind of, what to say, a kind of um, kitchen, like some food recipes. I cannot say the food recipe is invented by me. It is not possible. You need to invent something which is new, which is non-obvious. Which is non-obvious means non-obvious to the skilled people. For example, a carpenter is skilled in a carpenting the furnitures, and I invent something which is obvious to that person, then that won't be patented. So I need to invent something which is non-obvious to the skilled person also. And it is applicable to the industry. Something which is useful actually. So all these things needs to be examined, and at last the government will give you a grant patent. So this is utility patent. Now coming to design patent. Design patent comes under the Designs Act 1970. So designs, for example, I've designed something, designed a sari, designed a bag, designed a water bottle, anything. I need to show the design. I need to show what and all graphs I've used. And the design will be the front view, the back view, the right view, the left view, the upper view. All these things I need to showcase and I need to put forward. Within 3 to 4 months, if my design is unique, if my design is non-obvious, then my design can be accepted. Design patent in India has a grant and publication on the same date. So it is not like utility patent that publication takes place after that 1 year takes place for the grant. It is not like that. Design patent is like granted and published on the same date. And then we have plant patent. Plant patent is applicable to the agricultural side, for the farmer side. So there is another act. We have this Farmer Rights Act, where this kind of modification of the or microorganisms, Biodiversity Act also we have. So there the farmers gets a right if there is any kind of modification of the plant, they do it, or seeds. Those seeds act is not applicable, but yes, if the farmer is doing something unique on that, then the farmer can get the patent on that particular crop. So these are the kinds of patents that we have in India. So moving to the next slide, we can see that what is the definition of patent? So patent describes an invention which is applicable to the industry, not by any kind of inventions. Not something, creativity is not patent. Patent is something which is an invention. And yes, patentee has the exclusive right. It is an exclusive right. It is a monopoly right for the inventor or the patentee himself or herself. So, as I said, invention of patent can only be done if the invention is new, if the invention is useful, if the invention is not obvious, and obviously it is not coming under Section 3 of the Patents Act. Section 3 of the Patents Act is talking about the patent which is non-patentable. Like, for example, a mathematical algorithm or maths formula, all these things cannot be patentable. A mere admixture of something cannot be patentable. As I said, a cooking recipe. For example, my mother is saying that I know a very unique recipe you cook with this, and I say, see, this is a new thing that comes up. Even that will never be patentable. Something which will be unique, something is non-obvious to the skilled person. So this should be the scenario. So if something which comes up like this, yes, patent can be granted. So as I said, patent grant is very, very difficult. It is not that easy. And if you grant it, you get a strong protection for 20 years. So these are the patentable subject matter which we have in India. So it relates to both process and product patent. It is not only related to the product only, it is related to the process as well. For previously what happened, it relates to only the product. So someone used to make the same process and make, for example, they used to make x plus y equals to z. So they used to do x plus y equals to a. So the product is different, but they used to use the process same because the process was not patentable. Now government has changed it. Government said no, we should give patent for both process and product so that it will be stringent. No one can copy it. So it involves an inventive step. It is capable of industrial application. And as I said, it ought to be a machine. It is not something which is creative. See, we can also say that a movie is also like, to publish a movie, it also takes a lot of process and all. But it is not a machine. It is something which is coming from the head. It is something artistic. It is something creative. So the life and duration of the patent is 20 years from the date of filing for all the types of inventions. Priority date, so pre-grant and post-grant is also there. So pre-grant is till publication, post-grant is from publication till the grant period that you are getting. So this is all about the life and duration of the patent. So this is the fees all about. This depends actually. So if you are going for, like, if you have hired a patent agent and you are going with that agent, then the agent takes a fees for this, and the government filing fees is this. So there are two forms. Okay, like for example, if you're going for utility patent, then form 1 and form 2. If you're going for design patent, it's form 4 and form 3. If you're going for plant patent, it's form 5 and 6. So these are the forms you need to fill it up. And yes, after 20 years, if you want to renew your patent, even you can renew. Because see, for example, a person who has done in the year 2005. So 2025, 20 years is almost covering up. So if someone wants to renew its patent, yes, you can renew before it gets lapsed. Okay. So this is all about the patent. So is a patent granted in one country enforceable in another country? No. There is nothing like a global patent or a world patent. Patent rights are essentially territorial in nature. So granting a patent in one country of the union does not force other countries to grant the patent for the same invention. So the refusal of the patent in one country does not mean that it will be terminated in all the countries. Now this is also a very interesting thing. For example, if I have, granted a patent for a skin cancer machine, like I have a grant patent in skin cancer machine. So it doesn't mean that it got granted. It is enforceable in UK or US. Mostly that particular grant can be done by some other people. So granting one patent in India doesn't mean that it will be enforced in other countries. So patent holders in India. So as you can see, the list of top 10 patent holders in India comprises only pharmaceuticals and biotech companies. That is so true. Like big, being into finance sector, being into law sector, it is very difficult for us to invent something. Someone who is in computer science, someone who is into, pharma industry, for them inventing something makes sense because there is a process and there is a product. So that's why top 10 of the patent holders are from the pharmaceutical and biotech companies. Apart from that, India holds 184 patents, which are from the Ranbaxy, as well as top 10 patent holders, are across from the world, which are the IT companies in India. No IT firm has patents, but IT companies, they have the top 10 patent holders because of Ranbaxy or other sort of pharmaceutical companies which are very, very famous. So this is the youngest patent holder on wheelchair. This is one of the examples that are given from Jaipur, who has, in is he has invented Stephen Hawking, a wheelchair bound 9-year old boy here has invented a game of 6-player secular chess. So we can see the picture here. So he got a patent, and the boy, his name is Rideshwar Singh Bhati has got the game's design patented in his. So I repeat myself once again, this particular patent is not invented patent. This is a design patent. So you can see the round chess. We have not seen a round chess ever. And this is a six player, like we generally see chess between two persons. But this child has invented a round shape chess where six players can sit and play the chess. So he is a 9-year-old boy who is sitting in a wheelchair and have invented this. So hats off to a child who has invented at such a small age. So invention can come at any age actually, but again and again, invention is just your idea. You need to publish it and you need to make the public aware that yes, I have done this. If you don't make the public aware, you have just an IP. You don't have IPR. To make an IPR, you need to make the public aware of it. If you just hold a IP, later on you cannot claim for the IPR. So I think IP and IPR holds a very great difference. Everyone can have a property, but to claim for the right, you need to actually have the registration of that particular protection. So this is how a patent copy looks like. So there will be certificate of grant patent. On the other hand, there will be the patent office, and thereafter there will be a registration number. So that number is very important because if you type that number in the ipindia.gov.in, you will get the entire details. So that's why that patent number is very, very important, and you will get the inventor's name as well. And the date on which it got patented, every details will be there. You cannot hide anything. Like for example, we also got a lot of patent design in my name or grant in my name, but I cannot say I got it or I cannot create it by myself because everything and anything is available online. So now move on to the next topic, that is trademark. So now what is trademark? Trademark is again which is related to the industrial application only, as trade is something business which is related to the industrial design, but trademarks is something about the logo, about the slogan, about the design, about the color variation of the design. So trademark, first it was the name of the trademark act was Trade and Merchandise Marks Act 1958, but in the year 1999 we changed the name of the trademark and we have named it very simply Trademark Act 1999. So trademark is also applicable to the whole of India, and there are lots and lots of cases we can see related to the trademark. And trademark is talking about a lot of marks, collective marks, service marks, functional marks, business marks, everything comprises of trademark. So let us discuss each and everything. So this is what you can see, that trademark is a symbol, is a logo, is a word, is a sound, is a color, is design, or any other device which is used to identify the business. For example, there was case like Lakme and Like Me. Then Starbucks versus Sadarbucks. So these are small, similarity, but which is deceptive similarity, because we know that Starbucks is a huge, form of a particular coffee shop, which has its brand value. And just if I say someone Starbucks, people can identify, oh, there will be one queen having these wavy hairs and a small crown. We know the mark, right? But Sadarbucks also made a similar kind of a logo, and the naming is also Sardarbucks, which is also phonetically very similar. So there are lots and lots of cases in trademark, and which is very common. We will discuss each and everything, but just to introduce about what is trademark. And trademark is also very interesting. And I would say that entire intellectual property rights is very interesting because this is very new and we should explore it because we never know where it ends, because we have started the exploration. And India is in that exploration that where AI should stand, because will AI will get the authorship, will AI will react in that or not? So there is a lot of questions which comes here. Okay, so you can see that the intent to use application file for a product which is written. So side, in the side you can see TM written, trademark. Then SM written, service marks. And then you can see R, which means registered. So trademark is a mark, but if it is not registered, the R, you can see now that R and there is a circle. That R and a circle means it's a registered trademark. If it is not registered, it will show TM only. TM means only trademark. If it is registered, there will be an R and a circle. So, in since the trademark is registered. So, let us see what is the registration procedure for the trademark. So, there will be an application for the search, application for the registration, examination of the trademark, advertisement of the trademark, filing of opposition, and certificate issue. So again, for the trademark, we have a website, trademark. So we need to go to that website. We need to apply. We need to first search that whether that particular mark is there or not. If there is not that mark, then what we will do, we will apply for registration. And then the trademark office will examine that yes, whether the trademark is new, whether there is no other deceptive similarity of that trademark. Then the trademark office will advertise that mark for opposition. So if no one claims for opposition, yes, well and good. The certificate will be issued that yes, you got a trademark for that particular logo or that particular name or that particular sound, that particular symbol, whatsoever, for which you are actually applying for the trademark. So again and again, like for example, if we buy a property, we go for search, right? The first and foremost thing that is that we go for search, which is known as due diligence. So, for example, we see that whether the property is not in the name of someone else. We say na, like if we like go for purchasing a land, what we do first is we search that property. Are wo property is not in someone's name na, whether the sole author who or the sole owner of that property is only showing the property to me, or there are someone else who is hidden, I don't know. So same thing goes here also. If that property belongs to someone else, there will be a search. And if it doesn't belong to someone, then you have the right to register that trademark in your own name. So then this is the duration of trademark. As we have seen, patent duration is 20 years. Trademark duration is 10 years. So 10 years patent duration, 10 years it's applicable. Okay. And for 10 years, if you get the trademark registered in your own name, you get 10 years time by paying the prescribed fees in the government office. You get the you get the trademark in your own name. Then we have the service mark. So service marks is also for 17 years and it can be renewed. Service marks means, for example, the Tata Motors. So Tata is giving you a service or any kind of service where like Uber. Uber is giving a service to us. So that Uber is getting a service marks which is valid for 17 years. So there is a government fees which is classified into goods or service. Okay, and you need to pay 2,500 for each of the classes. For example, if it's a goods, then you need to pay 2,500 for that goods. If it is service, for that particular service, you need to pay. So then is the applicability of the trademark. So applicability of the trademark is a sign that is used on the connection with the marketing of the goods or services. So any kind of trademark, like for example, a wrapper for eclairs. So in eclairs, there is a wrapper and we see the wrapper is golden color or blue or golden color. Even that container or wrapper, even that gets a particular color trademark or a symbolic trademark. So we can verify, identify, oh, that's a golden wrapper. So instance, it's a eclairs. So Kit Kat, it comes in red and white. So yes, the wrapper is red and white. So even if we don't see the Kit Kat written there, we will just closing our eyes also we can understand, oh, that's a Kit Kat. So even the content of the wrapper also gets a trademark. Even that's also have the goodwill of the particular business. So then we have the next thing is the setup or surrounding text. So Raymond Textile, you can see it has 60% of the market share. So because the textile, the nature of the textile, then Raymond Textile, even it's sometimes the fabric. See, sometimes the fabric of the particular goods also matters. Even the fabric, like Raymond, if we go to Raymond, the cost of the Raymond goods is higher. If we go to somewhere else, the cost is low. But yes, you need to see the texture. Even the textile of the particular goods is also mattering for the trademark. Then we have these sort of size also. The size, see, Vimal. Correct use is Vimal. Incorrect use is Vimal. Sometimes we can see that the first copy of Vimal or first copy of, many of the, Puma or Adidas, all these first copies are like, we can see in the market. So you need to identify which is having the trademark, which is not. So Vimal is having the correct. We should identify. Yes, this is the correct, logo, ADT, Fistura. This kind of things you can see the incorrect use and the correct use. So this is the kind of logo also that got their, trademark. So these now look into the spellings. Calvin Klein and Calvin Klein. Then Tommy Hilfiger. Tommy Hilfiger. See, these are the deceptive similarity. Tommy Hilfiger. And here also Hilfiger. MPC PG. MPC Portiers Gwalior. So sometimes the first copy is also available. But you need to identify which is the correct trademark, which is the correct brand. That's why we say brand values. So you can see these are the trademarks, the name, okay, Coca-Cola, the logo type, Puma, symbol you can see, the McDonald's, slogan, I'm loving it, color orange, which has a trademark, shape of the bottle, that is Coca-Cola. So you can see the entire Coca-Cola bottle has the entire trademark, and the Puma, the McDonald's, I'm loving it, orange color, all these, the color also. Sometimes the color variation also changes. And there are deceptive similarity. Deceptive similarity, like me, lack me. Phonetically is very similar. Are go to like me now. Like me, lack me, same hai. But no, it's not same. Like me and lack me is not same. Lack me as a brand. Like me is a deceptive similar brand, which is the first copy you can see. So there are so many first copies of a particular brand. There are infringement for this. But you need to identify which is the right brand for us. Now we are moving to copyright. Now copyright is something which is like, covered by the Indian Copyright Act 57, which got amended in the year 1982, then 1984, 1992, 1994 and 1999. So it is giving a unique expression of ideas. Again, copyright does not hold in ideas, it is in expression. For example, today I have an idea. I have an idea of making a film. And tomorrow I have shared my idea to X. And X has taken the idea and released the movie. Public came to know about X, not me. I can infringe X, but where is the evidence? So copyright exists in expression, not in ideas. Idea में कुछ नहीं रखा. Idea can be of anyone, but when you express this to the public and the public comes to know, then only the copy becomes a right. I'm talking about right. Anyone and everyone can have a property. Even the place where I'm sitting, it is not my property. I'm just sitting. I'm am having a possession of this property. I'm not the owner of the property, so I don't have any right. Similarly, if I have a particular movie as an idea, doesn't mean that I have an IPR. To make the IPR available, I need to make the particular movie available to the public. Then only the public will come to know, yes, so and so movie is made by so and so. Then I will get the copyright. So copyright needs to be original. Copyright is not talking about new, novel, non-obviousness or available to the industry. It is talking about it needs to be original. Now, how will you prove that your work is original? You need to prove your work original as you need to show that it is made by you. You have not copied from someone else article, someone else journal, someone else book, someone else photography, anything. So how to make the copyright original? You need to see that it is unique, it is novel, it is unique, and it is originated from my computer only. Okay, so there are Microsoft which is updated in my computer, and if the Microsoft is original, then it should be showing that yes, it is originated from my computer. There are softwares, you need to update those softwares. And even if you copy from someone else, you need to give a footnote that is coming under fair use, because fair use is one of the exception, or you can say it is one of the defense for academic purpose. We sometimes take someone else paper or someone else idea and write it down in our paper. So we need to give a proper footnotes that we have taken it from this particular person. Then it will be copyrightable and it is authentic as well. It is yes, someone can understand that I have taken it and I have given the footnotes for that as well. There are even certain plagiarism report softwares. Even if I write a paper, there are plagiarism report softwares where if you put up your paper there are AI software detection, there are Turnitin, there are Drillbrit, these kind of apps which are there. If you give your paper there, they will tell you that how much uniqueness that you have written and how much you're copied. So these are something which are very, very important in copyright. So copyright law protects expression of an idea, not the idea only. So if I have an idea and I share it with someone and that person has expressed it in the public, that person will get the copyright, not me. So even if you have an idea, please do it and express it and make the people aware of it. Otherwise, the other person can claim for it. So what is covered under the Copyright Act? You can see literary works. As like I am in academic field, so for me, I need to do a lot of research paper, journals, ISBN books. Okay, then conference proceedings, all these things which will come under literary works. Coming to the next is cinematograph and films. So cinematograph and films, we all know that belongs, remember that belongs to the producer, the not the director, that belongs to the producer. Next is dramatic work. Dramatic work means a person who is making a theater or drama in a stage, and that is something which becomes original. Some kind of drama which becomes original, they can take copyright for that. Next is musical work. So we know that musical work is something which belongs to the lyricist, not to the person who is the singer. For singer, it is a sound recording. The sound recording is belonging to the singer. For example, Shreya Ghoshal, Arijit Singh, they whatever the sound recording they are doing it for that particular T series or any of the companies, they are getting a sound recording copyright for them, so that no one can sing that song. They are getting the copyright for it. Musical means the musical lyric, the person who's composing the song, the lyricist. And last is the artistic. In artistic view, you have the paintings, the photographs. Okay, all these things are coming under the artistic works. So these are the things which are covered under the Copyright Act 1957. So next we have, these are the things which are not covered by the Copyright Act. Ideas, facts, recipes, works lacking originality, example, the phone book, names, titles, short phrases. These are something which is not covered under the Copyright Act. So as I said, ideas, then as I said, some kind of facts of the particular things, these are never copyrightable. Any kind of recipe, like like cooking recipe or something, these are never copyrightable, because these are these are something which lacks originality, something original. For example, I have choreographed a dance, okay, and that dance is totally unique, nowhere it is choreographed, so I can take a copyright for that, provided that no one, I have to prove that yes, that dance has not been choreographed by someone else. Yes, again, sometimes what we do, we make reels now. So we can see a lot of reels about some songs are there, and we make reels. Now that reels is not commercialized. We are making the reels for our own purpose to get likes, mostly in Instagram or Facebook, right? That is not copyrightable, because that is just for the sake of your own self. You are making it. You're copying from some choreography and making it. But yes, if your YouTube is like, you have a paid YouTube and you are getting paid from it, then you need to show to the YouTuber, like, the content creator needs to show that yes, the content is unique. Then only the YouTube will start paying you and it's commercialized. Then only the infringement thing will come. Otherwise, I'm just making it for my own sake. There is no commercial gain for it. No one will infringe, or no one will go also for infringing. So these are small, small things which you need to understand. Now, coming to the registration procedure, first and foremost, registration of copyright is not mandatory. If I publish a journal, or if I publish a paper in a journal, that doesn't mean I need to go and register my name in the Copyright Office. That is not at all applicable. But yes, to make my paper, which is available in the journal, to copyright myself, that actually prevents me from further infringement. Because, as I said, today I have, like, I have completed my PhD. My PhD thesis is available in Shodh Ganga, right? So anyone can see that because it's open access. Anyone can copy it. I'm not able to understand. I don't know also. No software is giving me an alarm clock that, see, this person is copying your paper. I don't have an alarm clock. So there lies the problem. If I register my copyright now, then if anyone copies it also, and later on I come to know, I can infringe that person. So copyright, if it is getting like registration, it actually makes your case more strong. Duration of copyright. Copyright gives authors lifetime plus 50 years from the end of the calendar in which the author dies. So author's lifetime, obviously it is there, plus the author dies from that time till the entire 50 years. Now in India, it is the 60 years. So basically 60 years, but there are divisions. If it is a film and sound recordings, then it's 50 years for films and sound recordings, 25 years for typographical arrangements of a published editions. And copyright protection always expires on December 31st of the last calendar year of the protection. Now, when I was speaking about the copyright and everything, I told about the fair use. Fair use is nothing but one of a defense. If there is no copyright registration, sometimes people take a defense for it. What is that? For example, today I want to make a project for my college, or I want to make anything which is like, which I want to, which I want to get it available. So what I do is, like, I type and I get a particular article which is very good. So what I do is, like, I copy paste some of the other things and I go to the Word document. There is a thing known as like, insert. There is AB, like, one, there is footnote, and I definitely insert that footnotes and give the name of the author which can be in iLife format or Oscola, or it can be Blue Book, or it can be Chicago format, anything. So what I do is like I give the format of the footnotes and I say that this is a fair use. So fair use is nothing but it's a permission which is given by the Copyright Act to a particular person who is taking the idea or expression of that person and making it in his paper, which is available to the public. And I'm even giving recognition to that person from whom I'm copied. So that that person cannot say, yes, see, my name is taken and my idea has been taken and he has not given me the recognition as well. So fair use is a kind of an exception where I definitely can take the idea or expression of someone else, but again and again, I will not be within the purview of infringement because it's a permission I've taken. So beware of fair use excuse. Never assume that your use falls, that the fair use exception, saving money is not a sufficient excuse. Laziness can be a instance. I cannot say that, okay, I was just sitting, I didn't go outside, I've not done any of the research, and I've just liked it, so I've done it. So laziness, all these things cannot be a kind of fair use excuse. And yes, one more thing. We have heard about empirical research now, which is known as non-doctrinal research. If you are doing a non-doctrinal research, no one can question your thesis, even your journal also. If you have done a part of empirical thesis by even, secondary research also, you have floated a Google form, you have got a idea from that, and you have justified your paper by giving that. No one can question your paper because that paper becomes unique. Even though you have taken footnotes or fair use from someone, but if you have given a touch of empirical research, no one can question your research because that research anyway becomes unique. Because the Copyright Act talks about what? Originality. So if you're copying from someone, you cannot claim copyright. But if you are doing an empirical research, anyway the research becomes unique. So now is how much can I use? So we know that there is a plagiarism test. Also in many universities, it can be 10%. Sometimes it can be 15. So not above 50. So within 10 to 15%, you can take it from someone else, uh, work. Apart from that, the entire thing will be your own. So in Kolkata, Bidhannagar, society, academic advancement society, there are journals also, right? So we do keep giving our papers in that particular association, and the association have a certain kind of flag report where AI is detected, where the journal is detected, how much flag report is there. So 10% is authentic, sometimes 15% is taken. So 10 to 15% can be copied. Apart from the entire 90 to 85% can be from, taken from someone else. But most of the things should be there, your own written. So remember all these things. These are very, very important criteria for the intellectual property rights. Now I'm moving to the infringement part. Now, what is infringement part? Infringement part means what actually constitutes the infringement. Infringement, we know, where there is a law, there is a remedy. Where there is a right, there is a remedy. Where there is a remedy, there is a right. We know this, right? So, whenever we talk about right, intellectual property rights, we also need to see about what is the damage or what is the remedy that we are getting from damage. So as I said, where there's a right, there is a remedy. Where there's a remedy, there is a right. So when we are talking about IPR, we need to even see what is the remedy that this particular law is giving to us. So any kind of infringement, use, distribution, performance, etc., etc. If there is an idea, as I said, if we go to Sarojini in Delhi, I mean, I don't know anybody has visited. I have visited that place. I've seen a lot of first copy goods which are available, accessible at that to very cheap price, 100 rupees, 200 rupees. You grab it, and people are grabbing it. But does it not becoming, or does it not making the brand value low? Does it not making that particular brand for which they are paying so much? They are registering their brand, they are making the brand, giving so much of advertisement in the media so that people should come to know, does it not actually reducing the brand value? So here comes the infringement. If they comes to know, if they see that their kind of production or their kind of commercial money or profit is lower than the first copy person, then they can easily infringe. They can easily ask for damages. They can easily ask for their particular problem that they are facing, that their profit is low and the other person profit is high. So these are the remedies for the patent infringement. That is, an injunction can be filed, and like injunction means to stop. Okay, and the court can definitely go for and award damages, or the court can ask the patent owner to give royalties for the further use. So there can be two kind of patent infringement. One is civil, another one is criminal. So this is one of the case that I said that I will be discussing over the entire thing. That is, Apple sued the HTC over iPhone patents. So HTC has a kind, this is a phone maker which has filed the complaint with the US International Trade Commission. So basically 20 Apple patents related to the iPhone. So the CEO have stated that iPhone patent has been taken over by the HTC. So this was one of a very, very landmark judgment where like patent was sued by the Apple owners. So in a remedy for trademark, this is all about the patent. For a trademark infringement, a suit can lie in the district or the high court. So punishment can extend to 6 months to 3 years. So it can be permanent bans or engaging in commercial activities. Next is the example of civil enforcement action. So Adidas, as you can see, 3 suits filed by Adidas, Salomon AG in the Delhi High Court against counterfeiters. So as I said that Adidas, and you will see the name Adidas, how it is written, and the first copy writing of the Adidas is different. I mean, there is slight change. So counterfeiters can change it, and it is not possible for nominal people to understand it. So at initial stage, infringing goods was seized by the local commissioner. Cases were decreed recently, and damage of 15 lakh rupees was awarded to Adidas Salomon. So as I said that, for example, there was a case in copyright. Remember, in Bengal only, that there is a movie which has been like the hero is Dev, and the movie is Poranjai Joliare. So that Poranjai Joliare was a hit movie, and it was directed by someone else. And the in Hindi there was a movie known as this Namaste London. So Namaste London director didn't profit so much, and Namaste London came earlier. Poranjai Joliare came later, but Poranjai Joliare profit was high, and compared to this Namaste London. So when Poranja Joliare came, the storyline of these, Poranja Joliare was exactly same like Namaste London. It was thoroughly copied. So what happened? This Namaste London director filed a suit against this Poranja Joliare director, and later on it came to know as because it was a similar story. Though made by two different directors, the director didn't even ask the permission of Namaste London's director, and so the Poranjai Joliare director have paid a huge amount of compensation to Namaste London director. Though it is an example that I've given as a copyright, but the same thing I can give you for trademark as well. Even if you are taking counterfeiting the logo, slogan, anything, and your profit is much more higher than the original brand, and the original brand comes to know about such kind of damage, then definitely they can go for infringement thing. So remedies for copyright, just now I have given for Poranjai Joliare is one of an example. There are a lot of examples of copyright. So in copyright, there can be two kinds of infringement. One is civil. Like civil means where you are sitting with the arbitrator also, a mediator also, where you can fix your particular problem. Another one is criminal. So if it is criminal, then there will be imprisonment for 3 years and fine as per the claims. But yes, criminal cases of copyright can be at that level if it is an empirical research. If the research is having an empirical touch, someone has taken my empirical research and put it up in his paper or her paper, then only it can be of a criminal infringement. And the same thing has happened very recently in the year 2024 against the Delhi University Vice Chancellor. Delhi University Vice Chancellor was accused for this copyright infringement where he has copyrighted someone's thesis of PhD. And later on, he was behind the bars for 1 or 2 days and he got a bail. But this sort of copyright infringement can be a criminal. Now we can see copyright claims on the basis of underlying artistic works. So you can see Ritika Limited versus Ashwini Kumar, Ritika Limited versus Nina Talukdar, Ritika Limited versus Sajid Mobin. These are some of the designs, or these are some of the artistic work. You can see more or less are similar. See, the first picture, you can see someone is light, darker. Second one, it's in light, and the other one is darker. Third one, it's light, and this is darker, this one is light. But if you see the design, if you see the painting, it's same only. So these are some of the thin line, deceptive similarity that also can come in copyright act. So, but I didn't know called innocent infringement. What is innocent infringement? Oh, I am not aware of this fact. Oh, this also is there available in the public. These are innocent infringement. So no excuse for those innocent infringement. As we all know, excuse law, like ignorance of law is non-excuse act. Ignorance of fact is excuse act. For example, I don't know that I need to do this. I don't know about the fact about the particular thing. Like I went to a particular temple, and in that temple I cannot wear salwar kameez. I need to wear sari. That is a mistake of fact. I don't know the fact. Oh, in that particular mandir or temple, I need to wear sari and only visit. That is still excusable. But if I say that I don't know the law of that particular country, that cannot be excusable. So if I say I'm not aware of the infringement, I'm an innocent infringer, that cannot actually make your case a strong case or a defense case. You cannot defend yourself by saying I'm an innocent infringer. Because in the trademark, there will be a mark known as R or TM or SM. In copyright, you can see C or name or year. Example, Utsav Saris. The copyright will be C and 2011 to 2012. So you cannot say that I was not aware of the fact. Now moving to the IT Act. As I said that my topic for today is intellectual property rights along with the Information Technology Act 2000. Because Information Technology Act is the recent or the main, you can say the hit list. It is coming in the hit list because we are mainly moving our world from the physical world to the digital world. See, today I am giving this entire lecture through the digital world only. Right. So today I think whosoever will listen to me, whosoever will come to me, or whoever will come click onto that link and see the YouTube will come to know, yes, these are the things that ma'am has said, or these are the things Dr. Koyel Roy has said. So IT Act is very important because in this IT Act, anything and everything can be copied, unauthorized, distributed, and there are digital theft also. So when we are talking about copyright, we also have copy theft. When we are talking about digital rights, we also have digital theft. So what are these things? So nowadays, I think you have seen that when we go to the movie theaters, it is very strictly prohibited. Even in the movie theaters also, before a movie starts, there is a strong guidelines that comes to us. One is, so obviously we know tobacco is injurious to health. That we all know. Another thing nowadays it is coming, please look into the, whenever you're going and watching a movie, it's saying do not video any kind of movie from the movie theater. That amounts to copy theft, because whenever you are actually videoing that particular movie, you are videoing without the consent of the, like, producer or the director. So you have to take, because previously what happened, people used to videograph that particular movie and pirate it in the Facebook or Instagram, wherever. Okay, and from there it used to be shared. Someone is sharing, so everyone used to repost it. And at the end of the day, it was a huge loss for the people who are actually, creating that movie. So this particular article explains how IT Act supports IPR in connection with its IP laws and IP Act in this digital age. So legal framework of the Intellectual Property Acts in this: cyber security, e-commerce and data protection. We need to secure our data. We need to secure our cyber space. We have a privacy. You need to lock your Facebook. You need to lock your Instagram. You need to lock your entity. Don't give open access to everyone. Later on, we will only see, oh my God, my mobile has been hacked. My WhatsApp has been hacked. My Facebook is hacked. Why it is hacked? Because you are the one who is giving access to someone else. It is we, because see, someone who is sitting on that part of the world, I don't know. So that person needs my help to crack it. Without my help, it is not possible for that person to crack any of the apps that I am using. I am only giving the access to that person. And later on, I am shouting and going to the police, there is a cyber crime that has happened to. But you need to be very careful. When we are paying by Google Pay or any other applications, we need to be very aware that whatever the app that we are using, if we are using by any password, please do change the password every 21 days or every month. So these are some of the laws, these are some of the sections that is being there, which is guiding or protecting the intellectual property rights. One is section 43 of the Information Technology Act, that is protection against unauthorized access and data theft. Next, we have section 65 that talks about the tampering with computer source documents. Like, for example, someone is modifying the software code or anything without the authorization, without my authorization. For example, this particular laptop belongs to me. Today, I have a link to join. If on the opposite side, someone don't allow me to join, then I cannot access that particular website. So it is the accessibility or consent given by the other person. Then we have section 66 and 66B, hacking and data theft. Very important. Nowadays, a lot of things gets hacked. Facebook gets hacked, and then we see some kind of random picture coming out, and later on that person saying us that please don't see that particular Facebook that has been hacked. Section 69A, blocking public access to harmful content. So nowadays we can see that a lot of websites that has been blocked because there are certain kind of harmful content. So these sort of things which are protecting the like Information Technology Act is protecting the IPR. Section 79, intermediary liability. So in between, like we have the broadcasting rights. So someone is in between who is actually giving the right to the end user and someone who is taking from the owner. So there is someone who is intermediary, the network user, you can say. So even that person should also see to it, otherwise that person will be caught hold of. Section 72, breach of confidentiality. So some data which is shared online, that should be protected because that can be sensitive. So these sort of things are very, very important. And as we all know that if I am making a memes of someone else, and that is offensive. Okay, so I can share that meme. I got the meme from someone. I am sharing some to whom I'm sharing. That person is sharing. But now the question is, who will be caught hold of? The caught hold of the person will be who has first shared it or who has made it. These are the people who will be caught hold of. How the IT Act works with the intellectual property laws. The IT Act, along with the IP, Comprehensive Protectionist Copyright Act, Trademarks Act, Trade Secrets Act, these are very, very important acts. Along with the Information Technology Act, we also have the intellectual property laws. So these are some of the cases. Shreya's single case is a very, very important case, which we all know. This is a landmark judgment case. Tata Sons versus Bodacious Tatas is also a very important case of the Tata's trademark rights, which was misused by both the IT Act and the Trademark Act. To conclude, I would say these are the challenges which are being seen in the digital age. Cross-border issues, for example, cyber crimes that happens in multiple countries. Whom shall I caught hold of? Which jurisdiction is there? Are there any online protection? Are there any online courts for them? No. Evolving technology. As I said, artificial intelligence is coming, blockchain is coming, intellectual property rights is facing challenges day by day. Our intellectual property rights is becoming complex because of the AI. Lack of awareness, yes, that is another one. Most of the people don't know. The police personnel who are the, as I said, executive authority who are implementing the law, they are not aware of the intellectual property rights. So these are some of the recommendations that I made to make the intellectual property rights more strong is harmonize the law. How to harmonize it? That people should be knowing about it. There should be more and more conferences, more and more capacity building, programs. Okay, there should be judiciary should be more proactive. The judge should know about it. The police personnel should be given trainings for these things. And to conclude, I would say, create yourself rather than using other creations. Do not use competitors' mark in such a way that it harms competitor in unfair way. No comparisons that are likely to cause confusion. So you should make your own creation. There should not be any confusion. The IT Act plays a very crucial role in, we have these traditional IP laws, but you need to understand the data theft, the hacking, all these things we need to understand because there are so many applications, Facebook, then Instagram, then YouTube's, all these data acts are also very important, and these are some of the applications where we can showcase our creativeness. So these are some of the things we should be aware of. So technological advancement made the job of the creator easy. It is also made the job of the copier easiest. So with that, I would just like to conclude myself. Thank you so much.
Thank you so much, ma'am. It was really nice session with you. The way you have explained in detail about the IPR and IT Act. I hope the all students have understood in detail about how they can secure their intellectual properties and other things. Like you said about the arts, they can secure with the law. So thank you so much, ma'am, for your valuable time out of your busy schedule. Thank you so much, ma'am. With this, we are concluding today's session. Okay, ma'am?
Thank you. Thank you so much. Thank you. Thank you.
Thank you so much, ma'am.
Thank you.